Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every other Friday, Alex Ooley of the Ooley Law Offices in Indiana. And Alex, thanks for coming along today to start with.
Yeah, great to be with you, Paul.
Um, we got a topic we wanted to cover today, and this actually, a friend commented to me about this, and it's been a topic that's been on the fringe of my awareness for quite a while. I want to kind of flesh this out and go into a deep dive with you about it, and that's the topic of felons and firearms. And let me start with. And by the way, before we get into the topic, I want to remind everybody that if you want to get your questions in, comment on either the live Facebook or live YouTube video, or if you're catching us anywhere other than absolutely live, you can comment, or you can get a comment in by tweeting on, by going to Twitter and tweeting with the hashtag Bullet Podcast. Now, if we're not live, I'll get that and I'll save it, and next time Alex is on, we'll get that question in. But if you and if you are not seeming, if you're asking a question doesn't seem to get through, sometimes my software has issues. That gets through the fastest. It always bypasses the Facebook and YouTube algorithms. So, Alex, let's get started with the 44. Everybody, not everybody. I say everybody knows, but obviously maybe not everybody knows. Federal law says if you're a felon, you're not supposed to have a firearm. Let me begin with, are all felonies, because not all felonies are violent felonies, and there are differences between federal felonies and state felonies. Are all felonies disqualifications of your Second Amendment rights?
So the short answer is no, and I want to give a little bit of a disclaimer here. Obviously, what we say here is not legal advice. It's for educational purposes only. I normally give that disclaimer, but I especially want to give that disclaimer here because this is can be a pretty sensitive topic, and people can make a lot of mistakes with respect to this particular issue. In fact, I've had clients who were mistaken about some misconceptions with respect to felons and possessions and how long felonies acted as a disqualifier, et cetera. So make sure if this topic applies to you that you consult with an attorney in your jurisdiction and get some legal advice from somebody who's familiar with the law where you are from. So once again, this is for educational purposes only. But going back to your question, Paul, are all felonies disqualifiers? And the short answer is no, but the answer is a little more complicated. So in under federal law, it's a federal statute. It's 18 USC 922G. It says it prohibits firearm possession by persons convicted of a crime punishable by imprisonment for a term exceeding 1 year. Now, that's typically going to be a felony because misdemeanors are ordinarily, in most jurisdictions, only punishable up to a year, not more than a year. So that provision under federal law would seem to prohibit anyone convicted of a felony from possessing a firearm. However, there is an exception to that. Under 18 USC 921A20, that statute, again, a federal statute, excludes anyone convicted of a federal or state offense pertaining to antitrust violations, unfair trade practices, restraints of trade, or other similar offenses relating to the regulation of business practices. So this exception under federal statute is commonly referred to as the business practices exception. Now, what constitutes or what falls under this business practices exception is not so clear, and the various federal district courts apply this exception a bit differently, and that can get pretty nuanced. But the bottom line here, and the point I'm trying to make, is that most felonies are going to constitute a prohibition on your ability to possess a firearm. However, there is this exception, this business practices exception in federal law that would allow some people to possess a firearm even if they'd been convicted of a felony, as long as it's one of these business practices felonies. The other thing is that people who have been convicted of a felony may not necessarily be prohibited from possessing a firearm forever, even if it's not one of these felonies that falls under the business practices exception.
That was another question I had was, if you are prohibited, is it the one I hear a lot is, well, it's a 10-year exception, and then I've also heard 20 years. I've heard several numbers.
Yeah, so there's no automatic restoration of your rights after some period of time. There is no. It's if you've been convicted of a felony, you are prohibited from possessing a firearm forever, unless you expunge that felony or you have it pardoned. And that process is going to be, there is no process for an expungement of a federal crime, or actually, let me back up. There is, but the process and the ability to do that, or the mechanism to do that, has not been funded by the federal government for quite some time. So in effect, there is no process to get a federal expungement because that mechanism hasn't been funded. But most states have some mechanism to expunge felonies. Indiana is one of those. I'm from Indiana, and we help folks with expungements in Indiana quite frequently. But there's going to be a waiting period. Most states have some waiting period. So after some number of years after you've been convicted, you can file for an expungement. And as long as that expungement is one that's recognized by the FBI and the ATF as effectively expunging your record, that would serve to restore your right to possess a firearm. In Indiana, you have to wait 8 years before you can file a petition for an expungement. But it's not automatic. You have to file a petition for the expungement, and the judge has to grant it. So it's not something that just happens after 8 years or 10 years or 20 years. You have to request the expungement.
Starting to get some comments in here about this. DJ Play Nice, I want to get in the first comment here. DJ says, some municipalities have increased the penalties for misdemeanors of some very specific violations that would apply in that way. So, let me go to the 4473, specifically question C on the 4473, which is a form everybody has to fill out when they purchase a firearm. The question C is, have you ever been convicted in any court, including a military court, of a felony or any other crime for which the judge could have imprisoned you for more than 1 year, even if you received a shorter sentence, including probation? So let me ask this, Alex. If for example, if I were charged with a crime that was that I could have been put in prison for 2 years, and I pled to a misdemeanor and they put me in jail for 6 months, the original charge was 2 years. Am I still prohibited?
So the question and a comment and your question are slightly different, I think, if I'm listening to the question correctly. So if you're charged with a felony, for instance, which in Indiana is punishable, a level 6 felony, which is the lowest level felony, is punishable by up to 2.5 years, which is obviously more than a year. But if you enter some kind of plea agreement or you go to trial and you're only found guilty of a misdemeanor and it's less than a year, the conviction is to the misdemeanor, which was not punishable by more than a year. So that would not be a disqualification on your right to possess a firearm unless, and there's another exception, it's a crime of domestic violence. So if it's a misdemeanor crime of domestic violence, that would also serve as a disqualification on someone's gun rights. Now, I think what the comment was suggesting was that in some jurisdictions, there may be misdemeanors that are punishable by more than a year. And if I'm reading the comment correctly, I think that's what he's suggesting. So under the same statute that I referenced earlier, the 18 USC 921 that had the business practices exception, there's also an exception for misdemeanors that are punishable by a term of imprisonment of 2 years or less. So I believe the circumstances that the comment is suggesting would fall under that exception.
Okay.
One thing that's interesting is that Justice Amy Coney Barrett, before she joined the Supreme Court, she wrote a dissent in a case called Cantor versus Barr. And in her dissent, she argued that based on the text, history, and tradition of the Second Amendment, which we now know from the Bruin case is the appropriate standard for evaluating Second Amendment challenges, that nonviolent felons should not lose their right to keep and possess firearms. It will be interesting after, in the wake of the Bruin decision, whether the Supreme Court ever addresses that issue. And I say that partly because in the Bruin case, the court used the term law-abiding citizen. It was nearly 40 times. I don't know the exact count. But I wonder, I'm sort of reading the tea leaves a little bit. I'm wondering if the court was trying to maybe prevent this sort of challenge to the prohibition on nonviolent felons possessing firearms by saying law-abiding. Like I said, I don't know, and the court may at some point in the future consider challenges to the prohibition on nonviolent felons possessing firearms. And I think Amy Coney Barrett, at least, would be very receptive to that argument because of her dissent in the Cantor versus Barr case.
Well, my personal opinion is if they're too dangerous to own a firearm, why are they out of jail? That's always been my opinion, is if you're too dangerous to own a firearm, you ought to be remaining in jail. But the second part to that is this, and that is that sorry, my brain just kind of did a reset on me. I forgot where I was going with it, but let's see if I can get back on track here real quick. Going with what the Supreme Court this term has shown no fear in issuing unpopular opinions and returning Second Amendment rights to nonviolent felons would certainly be an unpopular opinion. So I would not be entirely unsurprised if they were to take that up down the road.
Yeah, I agree. I think this court has shown that it's not afraid to address real issues that affect individual rights. Maybe with the Dobbs case and also with the Bruin case, the court took on these issues head on. And I think the prohibition on nonviolent felons possessing firearms will eventually reach the Supreme Court. It's hard to say when, but I think that challenge will eventually make it.
One. Go ahead.
One thing I'd like to point out too is we mentioned the form 4473, which is the form that you fill out when you purchase a firearm from a FFL, a gun dealer. And question 21C, which you mentioned earlier, says, have you ever been convicted in any court, including a military court, of a felony or any other crime for which the judge could have imprisoned you for more than 1 year, even if you received a shorter sentence, including probation? Now, if you have received an expungement, you might think the answer to that question is still yes, because you were convicted of a felony. But that expungement operates to erase that conviction, essentially for the purpose of this form. And the instructions, in fact, say that if you've had an expungement, you should answer no to that question. And that's a pretty common question that people have about the Form 4473.
Let me get this question up then, or this statement up. Tim on the Facebook side says felon can restore rights, but misdemeanor DV cannot.
Yeah. Domestic violence.
Okay.
Yeah, a misdemeanor crime of domestic violence. So I think this is going to be state specific. So in Indiana, you can restore your gun rights even if you're convicted of a misdemeanor crime of domestic violence, but an expungement alone will not be enough. You have to file a separate petition to restore your gun rights, and then that whether or not to grant that petition is going to be discretionary with the judge. So it's not an issue. It's not a situation where after a certain number of years, the judge has to grant the petition as long as you haven't committed any other crime in that number of years since the conviction. The judge may grant your petition, and at least that's the circumstance in Indiana, and I believe in several other states.
All right, let me bring up another related, but in I often see it in popular media that if you have a conviction and you're prohibited from owning a firearm, you can still own a gun as long as it was what is it, 1892, or a replica of an 1892 firearm. Is that correct?
Yeah, I think it was 1898 under federal law.
Okay.
You might be correct about that, but I think it was 1898. So most states exempt antique firearms from licensing and general licensing and ownership requirements that you might otherwise have to follow for more modern firearms. And each state applies this exception to antique firearms slightly differently, and may define antique firearms slightly differently than federal law. But under federal law, an antique firearm is any firearm produced before 1898. And that includes, like you said, Paul, replicas of those firearms. So it could have been manufactured more recently than 1898, but it was manufactured to exactly duplicate the firearm that was made before 1898. So a firearm like that would still be considered an antique firearm.
Okay, so a Colt single action army, a replica, is not a firearm under federal guidelines.
Correct.
Okay. I don't know that I'd want to rely on one to defend my life with, but if it's all you got.
If it's all you got, exactly.
All right. Let me see if we've got any more comments coming here. The DJ going back to the some are specifically targeting firearms owners. Graffiti increased propensity was specific to if graffitiing was committed while armed. Apologies for not remembering the city. Okay.
I'm not sure what this comment's referring to. I apologize. Maybe a little more context might help, but I think are you referring to the misdemeanor crimes that are more than a year?
I missed one that was in between his I'm going to put up his first comment. That was where some municipalities have increased penalties for misdemeanors. Here was the second comment that I missed. He says, I can't remember where some linked firearms prohibitions to nonviolent crimes. One was for graffiti. And then we come with this comment. Some are specifically targeting firearms owners. The graffiti increased. Propensity was specific to if graffitiing was committed while armed.
Yeah, I think in those circumstances, as long as the penalty is not more than 2 years, it would still fall under the exception under 18 USC 921. Um, if I'm following the comment correctly, I think it would still fall under that exception.
All right, so let's. I think we've covered that pretty well. There's one story in the news today I wanna cover. This actually hit day before yesterday over on AmmoLand. This is by Lee Williams. It's my colleague here at SAF. Lee works for SAF as well. Uh, a a young man in Florida, Eunice Isaac Meja, was a good guy. He was a former police dispatcher, had never been arrested in his life until he unknowingly invited an FBI informant to shoot steel plates on his 5-acre property near St. Cloud, Florida. Turns out this informant was in trouble with the ATF and turned informant. And I know this person who put a brace on a scorpion they probably shouldn't have put on the scorpion, so they got the other person in trouble instead and therefore skated on what they were in trouble for. And this guy's going to spend 2 years in prison for putting a brace on the on a scorpion where a CZ Scorpion Evo 3 S1, and even he had a legal suppressor for it. He had the tax stamp. He had he everything was legal except for he put the wrong attachment on the firearm, and the nobody would comment when he reached out to the FBI, ATF. He reached out to nobody will comment on other than, well, it's within sentencing guidelines. And yet this is a nobody was hurt in this.
I think this is a total miscarriage of justice, and a complete waste of resources. It's amazing what the FBI did in terms of utilizing resources, targeting this person, and the only thing he did wrong was put a stock on a pistol that converted it from a pistol to a short-barreled rifle, which is a taxable item under the NFA. So, and this was all for what? He was doing nothing that hurt anybody. Yes, it was a technical violation of the law, but is that really what the FBI should be doing? Is targeting these folks who are otherwise completely law-abiding citizens and peaceful and good people? I don't know this person personally, but he sounds like a good person, an upstanding person, and he was targeted by somebody who was trying to get in the good graces of ICE. So
Yeah.
it just seems like the wrong result, and like I said, a complete miscarriage of justice.
Yeah, and Lee says it in the article. I'm going to agree with it. I think the FBI and ICE and ATF's time could be much better spent tracking down people who've threatened to shoot up schools. I think they could put a lot more resources into people who are threatening to shoot up schools, and maybe not so much people who might switch a stock for a brace. Because if he would have put a brace on that thing instead of a stock, according to Lee, he'd have been just fine.
Yeah, this sounds like an FBI that has nothing else better to do if they're out chasing individuals for violations like this. So, like I said, seems like a complete waste of time and resources.
Absolutely, it is. Again, my opinion. But Alex, we're coming down towards the bottom of the hour, man. Before we take off, is there anything you want to promote? Anything you want to plug today, man?
Nothing that I really want to promote. I mean, obviously, if people have questions and you're in Indiana about expungements or questions about felons in possession, I'm happy to talk to folks about that. You can find us at ooleylaw.com. We also have a firearms training business if people are curious about that, o2gungroup.com. We blog and post at both websites. And my dad and I, his name's Mike Ooley, he's been on the show in previous shows. We teach a 5-hour legal seminar about the lawful use of force in self-defense. And so if people are interested in those things, check out our website and get in touch with us.
Very cool. On my end, I want to encourage everybody to tune in at noon Central Time tomorrow, where Alex will be back. He and Dan Waz are going to join me for the weekend edition of The Bullet tomorrow. And for today, thank you everybody for contributing. Thank you for watching, and we will see you next time.